Sponsored by the Word on Wealth Radio Network. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, here, you're live.
Happy Tuesday, everybody. Welcome to the Word on Wealth. I'm really glad you're along today. We've got some fun things to talk about. I'd love to hear from you. I've got lines open today. We're going to do a live show, 888-344-1170. If you want to call us and ask questions about wills, trusts, power of attorneys, trust administration. If you're acting as a trustee and have a question, if you're a beneficiary and have a question, let's get some of those questions aired today and be happy to answer them here on the air. We're going to be going right to the top of the hour. We're going to keep lines open until they're full, and that is 888-344-1170. I was in doing this for as long as I have, and I say that a lot of times, like in doing this as long as I have. My wife was reminding me this morning, she goes, I know you've done this for 30 years, more than that, but it's like, it's okay. Just talk about things you need to talk about. And one of the things was my big deal. I believe I was put here on this earth to help people take care of their family, their life, to be available for people that really need help, not available for just people that have gobs and gobs of money and can do whatever they feel like. So in fact, my son Ryan said, Dad, you know what? I just figured this out. You actually help real people. Thanks, Ryan. I believe I do. So one of the big issues that I deal with quite a bit, it's not like disheartening, I guess I could say that a little bit, is that waiting too late to act. Sometimes you just wait too late. I mean, I understand procrastination. I understand that, some people think it's funny. Some people just really worry about it. Procrastination is it's with estate planning. Procrastination sometimes is a big problem. If you've ever had a wake up event, I notice a lot of people, I'll ask them, so what brought you in? And I'll have people, they'll say, well, we've known for a long time that we need to do an estate plan. And then I had a good friend of mine that got into a car accident and passed away. And so I thought, we probably should get things in order. And I had people during the pandemic, you would have thought during the pandemic, we would have been absolutely, flooded to the walls. People just like calling in or zooming in or coming in with
calling in, Gary, you have a call. We have Jesus that wants to ask you a question.
All right. That sounds great. Jesus, welcome to the Word on Wealth. This is Gary Quackenbush. How can I help you, man?
Yeah, I have a question. Unfortunately, my mom had passed away from mesothelioma last year, and she had a settlement going on with her case, and she had put the money from that settlement to go towards a living trust for me and my sisters. And we were just wondering if that was going to be tax deductible, or how does that work?
Okay. When so mesothelioma, so has the settlement already been reached and they're just waiting for it to pay out, or is it still being worked on?
Yes, it's already been passed, and my mom passed away unfortunately last year.
Okay, I'm sorry to hear that.
Any
money that you get from if you're inheriting, unless it's like an IRA or something, it's not taxable to you. It's not taxable to you unless the number exceeds $12 million. Okay, the number last year would have been like $11.62 million, something like that. But as long as it's under that, which is, I know it's like an alarmingly large number, but it won't be taxed to you. There's no inheritance tax on it or wealth transfer tax. There's no income tax. If there's any tax at all, it would have been a tax consequence to your mother. So she, that's got to be dealt with. As far as money on a settlement, it depends on how the money was paid to her, right? And so if she received it while she was alive, then there's going to be some issues on the tax return as to, that money. If it was for actual personal injury, then personal injury damages are not, they're not taxable. But if you get damages, for reimbursement for different things, because sometimes the way it's set up is the the payout is for multiple different things. So that's probably something to get checked out, is whether your mom owes taxes on it, and that would be paid from the amount of money that she gets. Anything that is net goes to you.
It just recently got settled this year, so she wasn't alive to get to see any of it.
So there's still gonna, because that's called IRD, it's called income in respect to decedent. And it's because it was money paid to her. I mean,
Right.
it was money, basically, it wasn't actually paid to her, but she was entitled to that money before she passed away. It's just, it took them, probably what happened is it just took them a long time to work through the numbers and everything like that. But if it's money that was
Right.
paid to her, it just was paid after she passed, then there's going to be some tax consequences. If it was money that was paid to you guys, but I don't think it wasn't paid directly to you, right? It was paid to your mom.
It went straight to her. She made a will, and it went straight to her living trust that she made.
Okay. Yeah. So you got to check into that, because there's going to be, she will have tax consequences because it's part of her taxable estate. And that's going to be something to take a look at.
Mm-hmm.
Yeah. So think about that.
And
As far as money going to you, it doesn't, from your mom to you, not taxable. From anybody else to your mom, it's potentially taxable, just depending on how the settlement was actually paid out.
Okay. Well, thank you. Really appreciate it.
You're welcome. Good luck with that. Let me know if you need any help. Just call us at the office, 855-500 trust. We can give you a hand and get you to my tax guy.
Okay, thank you.
Okay, you bet.
All right.
All right, Jesus, thanks for calling on that. That was really good. We got lines open, 888-344-1170. Give us a call. Let me answer your question. If you have anything regarding estate planning, estate settlement, trust administration, if you're a beneficiary and have a question, if you're a successor trustee and have a question, if you want to have a question, if you want to have me answer your question regarding your own estate plan, will or trust or power of attorney, then let's hear it right here. 888-344-1170. So the issue of waiting too late is really a big one for me. Because if you wait too late for estate planning issues, it's just too late. I mean, how do you fix it? So I want to talk about some of the wait too late things, so you can kind of figure out what you can and cannot avoid. Because I know we think in terms of, I'm not going to get life insurance. I don't know when I'm going to die, but I'm not going to die anytime soon. So I'm not going to get life insurance anytime soon. And I guess that's one way to think about it, but it's, that's a big gamble. You're kind of gambling the support of your family on, you're betting you're not going to die. But, once you have a car accident or hit your head or something like that, you kind of like go, oh, whoa, that was a close one. I'm glad that was a warning shot. And sometimes we don't get warning shots. It just happens. So, waiting too late. So if you wait until you are considered, there's two types of things. There's an incapacity and a disability. If you wait till you're disabled, that's not a problem, because disability, that's something you might qualify for Social Security disability or something like that. That just means you can't work. But incapacity means you can't think and make legal decisions. So if you wait until you're incapacitated, and it might be because you smashed your head, you got into a car accident, it might be because of disease or age or something. But if you wait until incapacity, then you can't do anything. It is what it is, and what you have or don't have, it's just stuck in place. That's it. So waiting for incapacity, not a good idea. Get it done before anything like that happens. I want to keep talking about that a little bit. We're going to keep lines open at 888-344-1170. Off the air, directly call me, 855-500 trust, and we can help you out with any of these issues and your estate planning. And coming up next, we're going to keep talking about what's too late here on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST. You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there, filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
You're not alone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQLaw.com, 855-500.
You're live.
Hey, welcome to the Word on Wealth. The number to get on the show with me, it's 888-344-1170. So call and ask your questions. We had a great question in our first segment from Jesus. We really appreciate you calling in. Give us a call, 888-344-1170. Waiting too late. It's a big deal for me. I mean, dealing with estate planning, you wait too late, there's nothing you can do. So you don't want to wait till you have that car accident or till you become injured or sick, or you get sick enough to where you now don't have capacity. The thing that happens is if you are, if you end up waiting too late or kind of where it seems kind of sketchy, then if you make a change, you cause all kinds of interesting reverberations or repercussions in your family. And some of your kids are gonna be saying, well, I know dad was off his rocker and he was not doing well. And he called me the other day and said, oh my gosh, I can't remember my home address. And I know that amendment was wrong or whatever. If you wait too long, you're just causing problems that could be avoided. The reason you do your living trust is so that you don't leave a big mess and you have things organized. You don't go to probate. Your estate doesn't go to probate. Your kids don't have to go through the probate mess and spend all that money and time and energy and emotional drain. So if you're going to be organized and have your trust, get it done right and get things changed like you want while you have the capacity. Do not wait until, your trust is 25 years old and you couldn't remember, you don't remember what you wanted to change. Just don't wait. Get it done sooner rather than later. And I know it seems like a hassle. It really does. But, sometimes you just got to do the things you got to do along the way. And that's why I am here. That's why I was put on this planet. To get a hold of me directly, it's 855-500-TRUST. Let me do your trust for you. And let me do your will, your power of attorneys, and take care of that. If you're waiting late, if you're waiting late to get documents, you wait too late, that your signature, what happens is the signature can be challenged, that you're invalid. Invalid signature, invalid document, the changes you're trying to make would become invalid. Now, I know, I've had people say, but Gary, my will and my trust say, thou shalt not fight this. And it has a disinheritance clause that says, if you contest this will or contest this trust, you get disinherited. Doesn't that apply? It does apply, but, big but. It applies, but if you're incompetent when you're signing things, then somebody challenging and saying, hey, that thing is invalid because dad signed it while he was incompetent. That's not a trust contest. That's challenging the validity. It's not challenging the terms of the trust. It's challenging the validity. That's not a trust contest. So you got to be careful with that. And that's another thing too. If you have a trust and it's an old trust and it says on here, if anybody that contests this trust or will gets $1, or anybody that contests this trust or will gets disinherited. In California now, we've got to go a lot deeper than that, because if it just says if you contest this trust document or contest this trust, you are disinherited or treated as if you'd predeceased the trustors without issue. That's not good enough anymore to really disinherit somebody, because the rule is that if all it says is if you contest this trust, what does contest the trust mean? I know. That's what the law says. What does it mean to contest the trust? So the paragraphs that we're using now, if there is an issue of contest, or you think there might be one because you're paying one of your kids less than kind of a proportionate share, or you're not paying one of your children anything, or you're not naming one of your children, you're probably going to be, the estate will probably be contested. So what you do is you put a paragraph that serves the purpose for the no contest. And it goes further and it explains you cannot contest this trust without being disinherited. Here's what a trust contest is. And it'll say, if you challenge this trust by hiring an attorney, by working in concert with somebody else, by writing a letter, and it goes through and it defines what trust contest means. And it's not a contest if you're objecting capacity, like if it was done properly. But it is a contest if it's in your list saying, I know what I'm doing. If you challenge me on this, you're disinherited. And so our new anti-contest paragraph is a lot longer than our old one used to be, because over the years of doing this, the California law changes, and as it changes, we update. So when somebody says, "Oh, my trust is 20 years old, is it okay?" It depends. The no contest clause will be ineffective today. You have things, that disinheritance clause that may be ineffective. There are some things that we used to do to trustees, 20 years ago that we can't do anymore. We need to give them different authorities and stuff. So if your trust has been in existence for, 15 or 20 years, it's done its job, you guys. Just get a new one. You don't have to change the title to your house or that. It stays in the name of your original trust, but we do what is called a restatement. We take and we basically start over. We name the trust exactly the same as your original one. So that way your bank accounts and your car and your house and all those things that are named or titled in the name of that trust, they stay titled in the name of the trust. And the new trust is just all the contents between the first page and the last page, all being replaced. It's an amendment and complete restatement. All the new laws, the new powers, the new no contest clause. That's what I would do. Call us. They'll take care of it. 855-500-TRUST. If your documents, if you've had them 15 years, they did their job, man. If you've had them 20 years, they really did their job. There's kind of an expiration date on some of these things, I think, because the law changes. It changes enough to be concerned about. And my suggestion is to get it taken care of, get it fixed. What if you wait too late to fund the trust? Okay, call me up, 855-500-TRUST, or call the show. Let's do it, 888-344-1170. If you have another caller, I'd love to talk to you, 888-344-1170. Call us on the show. Let's talk about your trust and some questions that you have that on it, or your estate plan. Okay, what if you're waiting too late to put stuff in the trust? Gary, what do you mean? I mean, I don't know how many times this has happened, but I have somebody that's passed away. The kids come into me and they go, okay, here's dad's trust. And it says, we get everything. I go, okay, great. Let's see what's in the trust. And there's nothing, no bank account, no house, no car. And they go, well, no. Dad told us the house is in the trust. And I said, well, here's the deed that put it into the trust. Here's the refinance deed that took it out. So it is not in the trust. It has not been funded. Technically, the trust is invalid if there's nothing in it, but we can deal with that, and we will do a legal procedure in probate court that has a judge do an order that says, yes, this house is supposed to be in the trust. We see it listed on the Schedule A. But that can be done, called a Hegstad petition. We do them way more than we should have to, but I'm happy to do it. If the house is not in the trust when you pass away, we're going to have to do a Hegstad petition. That's just the bottom line. You cannot avoid it because it's a title. It's like a bank account. It's like an investment account. It's a title, and the only way to move it is have the title correct. So before it's too late, make sure your house is in your trust. Make sure your car is in your trust. Make sure your bank accounts are in your trust. Go ahead and leave, some money outside of the trust, like a checking account or something, maybe a small savings account, but not very much. Put everything in your trust. All right. So let's say you got a situation where, dad passes away and now you've got mom, and mom's trying to straighten things out. We're trying to get her to put stuff in the trust, but mom's losing it. She just doesn't feel like she has, it just doesn't feel like she has the capacity, and yet we need to have her signature on something. Well, if she is incapacitated and can't sign documents, can't sign the title to the house to transfer the house in, the documents have not been put together right, you got to go to court, get a conservatorship. So your mom becomes the conservatee. You can become the conservator. There's court investigation. There's appointed attorneys for her. That process, it takes anywhere from 3 to 6 months. It's expensive, very expensive. And if she is deemed incapacitated and that she needs a conservator, then as a conservator, you can put money in her trust. What would have been nice is to make sure before she became incapacitated that her house and her money was in the trust. Then we don't need a conservatorship because we have a trust with a successor trustee, which could be you. And that successor trustee has the authority to spend the money and take care of mom and, help her live where she needs to live and all that. But if mom waits too late, if she's incapacitated but not dead, that's better. If we can get a conservatorship and move property in, but after she passes away, it all goes through probate unless it's already sitting in that trust. How can you avoid a conservatorship? Great question. I have all these questions written down. You can avoid a conservatorship by having the following: a living trust with your property properly funded into that trust. House is titled in the name of the trust. Car is titled in the name of the trust. Bank accounts are in the name of the trustee of the trust. Any documentation, anything you have that you can own and you have title to, if you transfer that to the trust, that's going to make it so that you can avoid a conservatorship, because the conservatorship is going to be one of two things. One, conservatorship over the estate. Well, if the estate, which is all the money, is in a trust, we don't need a conservatorship because we have a successor trustee named. When mom becomes incapacitated, we can step in. You can step in as the successor trustee and manage her money. It's awesome. I'm telling you, this really works this way. I know it seems unreal. Call us, 888-344-1170. Get on the show. Ask me a question. Happy to answer it. If you're a beneficiary, if you're a trustee, if you're trying to put together your estate plan, 888-344-1170. Let's talk about it. Now, what about the other part of the conservatorship where you have a conservatorship over the person, meaning making medical decisions to treat or not treat, to put life support or not life support, to, anything dealing with the body, where to live, where to stay, who to have a relationship with. All that is controlled by a conservatorship of the person. How do you avoid that? Well, before you get in that position where you are incapacitated, get a power of attorney. Financial power of attorney will work better. If we're talking about just person, get a medical power of attorney. Have somebody become your medical power of attorney, authorized to make medical decisions, to treat or not treat, to donate organs or not, to put you on life support or not. A medical power of attorney and a well-drafted, funded trust. Those things will prevent a conservatorship almost every single time. It is way worth the money. It is way worth the money. The amount you're going to pay for a conservatorship far outstrips what you would pay for getting a good living trust put together. Call me, I'll help. 855-500-TRUST, 855-500-TRUST. Coming up next, I got a couple of things. I'm going to do the case of the week, man. I got a really good one coming up next here on the Word on Wealth.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com. Of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQ Law.
Right. Hey, listen to the Word on Wealth. How cool is that? All right. So I am going to go. What just happened to my notes? I love it. Okay.
Your notes that involve the Gary Quackenbush GQ Law case of the week.
That one. Case of the week, man. Here we go. All right. So case of the week. These are always fun. I've had clients tell me, Gary, I really like the cases because these are really true. All righty. Mom passed away 2 years ago. Dad passed away 12 years ago. This is so typical. Sister is successor trustee. Sister moved in with mom 5 years ago to care for her. Sister is still there and had a friend move in. Okay. I think some of you are going like, oh, Gary's talking about my story. Well, there's probably 100 of you thinking that. Sister says mom and dad said that she could live there for as long as she likes. Brother says that mom and dad said no such thing. What do you do? Okay. What do you do? Great question. Call me up. Give me the answer. 888-344-1170. What do you do? 888-344-1170. Okay. This is something that we deal with on this radio show a lot. And that is, sister says, mom told me this and that and the other. Dad told me this and that and the other. Okay. However, it's not documented. It doesn't say mom said that. We look at the will. Understand, please. When mom and dad are not here anymore, the only thing we have is what they left for us to read, and that is a trust. Everything that we are going by, when it comes right down to it, everything we are going by to determine what mom and dad wanted is all secondhand evidence. Nothing is, it's not directly from them. The only people that really knew exactly what they wanted are gone. Mom and dad can't testify. Okay. I know Google's working on that, but mom and dad can't testify. And so we have to go by other evidence, the next best thing. That means we got to look at a trust. The trust has to be the original, folks. It can't be a copy. If all you have, if you're going through your mom and dad's stuff and they're still around and you go, Dad, where's your original? I don't know. Maybe it's in my safe deposit box. I don't know. I haven't seen it in 10 years. And you can't find the original. All you have is a copy. You've got to get a new one, get a restatement. Like I was saying earlier, just get a new one. You have to have the original, or you can go to probate court after they pass away and spend a small fortune getting a judge to determine, yeah, that copy is the original. We're going to call it the original, but it is really easy to object to that. Really easy. Because if you're trying to say that the copy that we have, that is the original, we're going to call it the original. What you have to establish with evidence to convince a judge is that the trustor, the creator, did not destroy it. And the presumption under California law is if the document is last known to be in the possession of the trustor, that's what happens. It's their estate plan. It's in their possession. Safe deposit box, their safe, their bedroom, their bookshelf. It's last known, last seen, its last place that we saw that sucker was in dad and mom's possession. Then it is presumed that it was destroyed by them, because that's all we can assume. If all that exists is the copy, we have to assume they destroyed the original and they just didn't find the copy to destroy it. So if you walk in with a copy, the judge is going to go, where'd you get that? Oh, mom gave it to me. Where's the original? I don't know. Well, mom destroyed it then. That's what's going to happen. And you have to go beyond that. Now, proving it, you got to notify your brothers and sisters. I'm trying to say that this trust is the original. And if that trust has anything unique, like brother has been disinherited, sister gets in the live in the house for 2 years, anything like that, it's going to fail on a trust challenge. You got to be really careful. So if you're looking through your mom and dad stuff, if you're looking through your own stuff and you go, whoa, I don't have my original anymore. What the heck happened to it? Where did it go? You got to get a new one. The bottom line, because an original, it's not going to be any good. It can be challenged very easily. Just get a new one. Just get a restatement. I can help you with that. Okay. So in our case of the week, sister's been living there for 5 years. Mom died 2 years ago. Brother says, hey, I have the trust in my hand, the original. And it says, after mom and dad have both died, we split everything. I want my half of the house. I want my half of the bank account. His sister says, that's not what mom wanted. Mom said I could stay here for as long as I want. I'm sorry. The document says half and half after mom and dad died. You've been here for 2 years. Here's part of the problem. Sister has been living there for 2 years with no proof that she was allowed to. None. As of the date of death, sister owes rent to the trust because she's been renting the house. She's been living there for free. While mom and dad were alive, they have complete authority to do whatever they want. So while mom was alive, it is no problem for mom to say, yeah, daughter, you can live here rent free. You don't have to pay anything. I'll pay for your food. I'll pay for laundry. I'll pay for utilities. I will pay the taxes, whatever. She can do that. And it might be in exchange for sister taking care of mom. Maybe, maybe not. But it's okay for mom to do that. When mom passes away, all bets are off. Her authorities stop. They don't go beyond the grave. Just doesn't work that way. She dies, so does the permission. So immediately on mom's death, sister has no permission to live there unless she can provide some, what we call competent evidence to prove that mom amended that trust to allow her to live there. Or there's some notarized statement or witness statement, something to indicate that mom said that she could live there. But if it's just mom said so, it just doesn't, it won't stand up. I'm sorry, guys, it just won't. So now sister owes fair market value of rent to the trust. Now, sister could argue, hey, it's half my house now and half my brother's, so I'm only renting my half. Or I'm only renting, yeah, I get to live in my half, I'll rent, and I'm renting my brother's half. So basically she would owe the trust 50% of the rent. Okay, but it's calculated, it's calculable, it's math. You just have to do that. That's what the law says. Okay, so that plus if there's any destruction and if you're fighting to get sister out, here's the big thing, you guys, with the market like it is, if you're fighting to get sister out and it takes you, if you have to go through the, get out, can't stay there, get a court order to kick her out, get an eviction, whatever it takes to get her out, you have to legally force it. It's going to come out of the trust, and you could try to get a court order that forces her to pay it. So that's a possibility. So the longer she waits, she's going to have to pay rent. She's going to have to pay all for the kick out orders, all that stuff. And that gets charged against her half of the estate. So that may be worth it. That may inspire sister or brother, whoever's living in the house, sister, in my example, it may inspire them to get moving. It happens. Okay. So, and I'm sorry, that's the way it is. That's just the way it is. If mom and dad die and you don't have anything in writing that you can stay there, my suggestion is you make arrangements ASAP. And, face it, you're going to get half the value of the house. You can rent an apartment for a very long time on what you're going to be getting. You can buy a house. You can put a down payment. If you don't have a job yet, then go rent something, get a job. You got a bunch of money for a down payment, put money down on a house after you got your new job for the next 3 months or so. But you can do it. You just don't stick around. My goodness, this happens all the time. Sister or brother are stuck in the house. Well, brother lived there for 20 years with mom and dad, and now mom and dad died. There's nothing in the trust that says that brother can continue to live there. I'm sorry, brother can't continue to live there. That's the bottom line. There's nothing that proves that. Even if mom and dad sat down, brother and sister and everybody, and had a family council and said, after we die, we want you to let your brother live in this house for the rest of his life. Is that binding? Depends on who heard it. If everybody's willing to agree, but what are the conditions? I know this, let's lawyer this thing, right? What are the conditions? Mom and dad said, brother can live in the house for the rest of his life. Okay. And then mom and dad pass away and brother starts destroying it or letting it go, doesn't pay the utility bill, doesn't pay the property taxes, doesn't pay the mortgage, doesn't maintain the yard, doesn't fix the roof after there's a hole in it. How far is this supposed to go? I mean, was there things saying, allow your brother to live there for the rest of his life? Were they saying unconditionally, even though he's being a slob and destroying the place and making it so that your inheritance is worth zero? The judge isn't going to say that. A judge is going to say there's a presumption that he would maintain that property in a condition that's equal to fair market value or something, akin to the neighborhood values, and maintain that property. And if he is not, I think a court would order him out of the house, because it's not right for that to happen. Staying there is one thing, but you guys, you've got to write this stuff down. If you want your son to live in the house or your daughter, let's get it written down. Let's get it in writing. Let's get an amendment to the trust. Let's make it so that it says, so you can take care of that child of yours that needs that special attention, let's do it. Get it in writing, because if not, it's going to be a lot of problems and it's going to all come out of that kid's share. Call me and I'll help you with that. 855-500-TRUST. We're going to have lines open. We're going to keep lines open. 888-344-1170. 888-344-1170. I've just got a really big question about power of attorney. Do you need a power of attorney? Maybe or maybe not, but do you need a power of attorney? That's the question I'm going to answer. Coming up next, right here on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs, call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST. Listen to the
You're not alone. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500-TRUST.
Hey, we are talking. We are talking here. You listen to me on the radio. This is Gary Quackenbush on the Word on Wealth. Thank you, friends, for joining this show. Great to have you along. We are taking calls at 888-344-1170. If you are a successor trustee and have a question, if you're a beneficiary and have a question, if you are trying to put together your own estate plan, or you have an estate plan, or you want an estate plan, give us a call, 888-344-1170. Ask me your questions. It's been great. We've had a couple of really good callers that help guide our discussion so that I can get to you what information you need. And we are talking about incapacity, what's happening, when is it too late, that type of thing. And now we are going to talk about power of attorneys. Okay. When do you need a power of attorney? Okay, first of all, we have to define, Gary, what kind of power of attorney are we talking about? Are you talking about a healthcare power of attorney or a financial power of attorney? Great question. Thank you for asking. You're welcome. Glad I asked that question. The health power of attorney is sometimes referred to as a living will. A living will is actually just part of the healthcare power of attorney, also referred to as a physician's directive, instructing the physician what, directing the physician what your desires are. That's also part of a healthcare power of attorney. Sometimes it's also called a DNR or a unplug me thing, right? Those are part of a healthcare power of attorney that's put together the right way. Healthcare power of attorneys need to be drafted within the last, 8 years. So if yours is like earlier than 2015, it's not going to have all the disclosures it needs. I mean, maybe your attorney that put it together, 20 years ago, maybe they had this clairvoyance or this they could foresee that the Health Insurance Privacy and Portability Act laws were going to change in 2015, and they drafted that all into the document. I kind of doubt it. I know attorneys are pretty amazing, but if it was after 2015 when you had your power of attorney put together, I'm sorry, if it was before that, we need to fix it. I would get a new one if I were you, because you want it to be right. Think about power of attorneys. When they come into effect, when they're being used, it's when you cannot make the decision yourself. So if it's needed to direct what's going on, to make healthcare decisions for you or financial decisions, you're not going to be in a position to make those decisions. And as a result, you won't be in a position to draft any documents or sign anything that would help you. Get this done ahead of time. It's not that expensive. It's not that hard. It's something that's important. So when do you need a power of attorney? Every single person in the United States, let's just go California because I'm just a California attorney. Every single person in California needs a healthcare power of attorney. That's the bottom line. If you're over 18, you need a healthcare power of attorney. If you're under 18, you need a healthcare power of attorney. If you're going to go away to college or something like that, parents, listen up. If you don't have a healthcare power of attorney for your kid that you just sent with your money to college, and they get injured or have a health issue, the college will not and cannot legally talk to you about their health problem. You need to get a power of attorney. If you have kids going away to college, get a healthcare power of attorney for them. And if you're sending them with your money, I think you should get a financial power of attorney. Those are two things that college kids need when they go away. Because if you need to make a bank deposit or get money out of their bank, or something happens, how do you get their money? How do you make healthcare decisions for them? How do you even ask the health center if your kid is okay? Without the power of attorney, they're not going to do it. I know this is one of those, this is kind of our hard questions day, but they're not legally allowed to. Example. Okay. My son away at school, I can't find him. And so I don't know where he is. I was told that he had an accident and that there was a problem. Okay, how do I find him? He's not answering his cell phone. I call the health center, which is where kids at the school go when they're sick or have an accident, potentially. Call the health center, and the response is, hello. And I say, hey, I need to find out about my son. And they said, oh, is your son going to school at this institution? Yes, he is. By the fact that your child is matriculated at this university indicates that he is probably over 18. Therefore, I cannot legally disclose A, if he's even at this school, and B, if he's in the medical institution, because that would be a violation of HIPAA laws. It would be a violation of all kinds of privacy laws. I can't talk to you. Thank you. Sorry. Goodbye. So my kid at college with my money, and I can't talk to anybody about him. So I call his roommate. Hey, do you know where Tyler is? Yeah, he's in the health center. Would you please do me a favor and go there and take your cell phone to him so I can check to make sure he's okay? And that happened, and we're good to go. So when you send your kid away to college, make sure you have a medical power of attorney, and that would be your kid giving a medical power of attorney signed by him or her, giving mom and dad authority to talk to anybody about medical, and financial, giving mom or dad authority to talk to anybody about their personal financial. So medical and financial power of attorneys for going away kids. All right. When will you actually need a power of attorney? One is going off to college. Two is if you became incapacitated. And three, it would be if you are unavailable to sign documents. Right? So got all that? That means if your kid goes off to college, we got that one. If you're unavailable to sign documents, example, let us say that my wife and I are borrowing money. We're refinancing our house. Now, we don't do that anymore, but let's say we're refinancing the house and I get called off to do a seminar in Las Vegas with the California Society of Tax Consultants, which happens every year. And I'm gone for 3 or 4 days. And it just happens to be during that 3 or 4 days, we're having to close a real estate deal. And I don't know if I'm going to be back in 3 or 4 days. Maybe I'm going to be gone longer, whatever, but it's got to be closed. How does my wife sign my name? Because you need my name. We co-own the property. What I would do is I would give her a power of attorney that says, for the purposes of this real estate deal, Cheryl can sign my name. She is my attorney. She's my power of attorney. She can act as me. So if you're unavailable, you can get a power of attorney to take care of that. If you become disabled, you're going to need a power of attorney, healthcare power of attorney for sure, and perhaps a financial power of attorney. The only way to avoid the financial power of attorney thing is if you have your properly drafted estate plan, and that estate plan will allow you to have somebody else manage your finances. So you do not need a power of attorney, a general power of attorney, if you have a trust and your stuff is in the trust. But you do need a power of attorney if you have stuff outside of the trust and you become incapacitated. So power of attorney during incapacity, at death, your trust works. Incapacity, your trust works. No incapacity, no death, your trust still works. The trust works at all times. Power of attorney only works while you're alive. And some power of attorneys only work while you're incapacitated and alive. So those things. Okay, the next topic that I want to go over, I think this is super important. And like everything, I think it's super important. But there are some tough questions that we need to ask, and that we're going to have to go over. We're going to have to go over them one by one to make sure that we understand them. So that's going to be something that probably is going to tie over, a topic, a future topic where we can keep going. Now, before this show ends, I want you to know what's going to go on the rest of the week. Okay, we got Ken Pecos tomorrow on the show. Ken Pecos is our real estate expert. He's going to be talking about, I know it's hard to resist, but we're going to be talking about Silicon Valley Bank. Believe it or not, Silicon Valley Bank collapsing was good for the housing market. And we're going to explain that. That seems weird. Like, whoa, second largest bank fail in the United States, which would be the world, basically. How could that be positive for real estate? Well, Ken Pecos is going to explain that to us. And I think it's pretty incredible because we have a very a flexible market. We have a very robust market in the United States. And so even though you have these giant bank failures, there's some good news coming out of that. Believe it or not, for a lot of people, it is just horrible news. For some people, it's going to be great news. We're going to be talking about that on Wednesday with Ken Pecos. On Thursdays, we have Anthony Wright. What are we going to be talking about? I will tell you, I'm going to ask Anthony, our financial advisor, what about Silicon Valley Bank? How does that affect the market? What do we do about it? And he always has some wonderful idea like, we saw that coming and we've anticipated it. In fact, the market doesn't care. And he will talk about that and give us the positive story. It's going to be Anthony Wright on Thursday. All right. And then Friday, of course, we have our Finding Joy Friday. Finding Joy Friday is going to be coming up. So we will be announcing and talking about who we have for our guests on our Finding Joy Friday. And that will be coming up. So you guys, it's so good to have you along. I love that you are listeners of the show. I'm glad that you're interested. I'm glad you're getting your estate plans done. Please give me a call at 855-500-TRUST. Tell me you mentioned this show. You want an appointment with me. Let's review your old stuff. Let's get a new one put together. If your trust is like 15 or 20 years old, it might be time to just, it did its job. It lasted 20 years. Let's get a new one set up so everything will be good. This is Gary Quackenbush on the Word on Wealth from GQ Law. Call me 855-500-TRUST. Go to my website, gqlaw.com. Get my free stuff. There's this really cool book called Living Trust Basics. Living Trust Basics. It's on my website. It's free. 855-500-TRUST. We'll talk to you all tomorrow. This is Gary Quackenbush signing off. Noah, thank you for everything. Talk to you tomorrow, everybody. Bye-bye.
Tell a friend about the Word on Wealth, featured since 1995. With financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of Salem Media Group or its sponsors. The Word on Wealth with